Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for oral argument in 1 CV17 0723, Allstate Vehicle and Property Insurance Company versus Maile, and I hope I'm saying that correctly. Counsel, each side is allotted 20 minutes for oral argument. The appellant may reserve a portion of that time for rebuttal. If you wish to do so, sir, please keep track of that time using the podium clock. And out of respect for counsel and the court, I ask that those in attendance make sure that you turn off your cell phones or they're on vibrate. Counsel, we have read your briefs. We've conferenced this case just this morning, and we encourage you to keep that in mind when you present your arguments today. The proceedings will be recorded and posted to YouTube. So before you begin your argument, please state your name and the party you represent. With that, I will start with counsel for the appellant. You may proceed.
Your Honors, I'm Dale Robinson on behalf of Sella Maile as the wrongful death beneficiary in a wrongful death action. As you know from having reviewed the documents and briefs in this case involves a tragic situation back in August of 2014 when Sella Maile and her husband and the others in the house belonging to Amelia Maile were involved in a house fire, and as a result, later that same day, about 7 o'clock that night, Benjamin Maile, Sella Maile's husband, passed away because of the injuries that he suffered in the fire. The major issue in this case has to do with an exclusion. This is obviously a declaratory judgment action by Allstate Insurance seeking to have an exclusion applied, a so-called resident relative exclusion. And the major issue is, what in the world does resident or relative mean? Sometimes people think, well, that's an obvious question, but it's really not. Judge Hanna stated actually at the conclusion of the oral argument, he said, it seems to me that if the policy is ambiguous, you're going to construe the policy not to include a daughter-in-law within the definition of relative. So the question becomes, what is the definition of relative? And the problem that we have here is that Allstate, the drafter of the policy, never bothered to define the term relative. The exclusion that's involved, you have to actually look at two separate sections of the policy. One is the exclusion section that says we do not cover bodily injury to an insured person. Then you have to go to the definition section to find out what an insured person is. But interestingly enough, the definition section doesn't define what a relative is. It says an insured person means you, or if a resident of your household, any relative. That's all it says. No explanation for what that means. Now, it's interesting, one of the things that's important when we look at words that are undefined in insurance policies is there are some things that are important to the court's consideration and to the party's consideration in determining how to define undefined terms. Actually, interestingly enough, after these briefs were prepared, and as I was preparing for the oral argument, I found that the courts have spoken actually twice in recent months since all the briefs were done. One of them actually by this court, Hanfelder versus Geico Insurance. That was actually decided, the decision was filed May 22nd, 2018. And that involved an exclusion by Geico Insurance where they were seeking to prevent somebody from making a UIM claim under additional Geico policy from a Geico affiliate. And the issue was, what did the word us, which was undefined in the policy, meant? And this court found that us was an ambiguous term because you couldn't determine what it meant because it was undefined. And in that case, the court said that the claimant, who had been excluded previously by the trial court, could make a claim under this separate policy of a Geico affiliate because us was undefined. And in the course of discussing that, the court actually quoted from Ranger Insurance Company versus Culbertson, says words of exclusion in an insurance policy should be given strict tolerance when insurance companies choose to use words of imprecision. And in that case, the court determined that that word of the use use of the word.
Even if we agreed with that and said we're going to construe relative strictly, how would that help you?
How that helps us is if the term relative is construed strictly, then it's also construed obviously narrowly.
Right.
And when we look at the
Give
at
me
how
a
to
narrow construction or a strict construction or whatever phrase you want to use that would exclude a daughter-in-law and a grandson.
if we talk about just the daughter-in-law herself, then the exclusion that would restrict that is blood relative, and that's actually what Judge Hanna said. If it was ambiguous, that it would not include a daughter-in-law.
So you're, and I'm going to argue with you. I'm just trying to make sure I understand your argument. So the narrow, strict interpretation of relative that you would propose would be a blood relative only. So that you're conceding the grandson would not be covered.
Yes, Your Honor. The
so for purpose of argument, we can ignore the grandson. It's just the daughter.
Correct. The daughter-in-law.
Have you come across dictionary definitions or any case throughout the country that has actually defined relative in that, I'll say, narrow sense?
Your Honor,
only a blood relative?
There aren't a lot of cases specifically on this. The best case that has to do with this is the Frost case from Wisconsin that we cited in our brief. The Frost case dealt with every case is different.
Right,
obviously,
and Frost
we know
dealt
that.
with blood relatives.
And it dealt with blood relatives, but the court did find that the use of the word relative was ambiguous, and where they were trying to apply it to a blood relative that was like a third cousin, that was too broad. So even that, they said, wouldn't cover. I haven't found any cases, Your Honor, that say that, but I think when we look at the rules of construction that apply, the rules of construction that these cases, the Hanfelder case and actually a Supreme Court case in June, talk about in terms of applying you have to look at the particular case, and you look at it and you construe it narrowly against the insurance company. And the other case that deals with this is the Tufel case. I'm not sure how to pronounce that, but Tufel versus American Family Insurance. That one's CV17-1090, and that was decided by the Supreme Court just in June. And in that case, they talked about, when we're talking about summary judgment, we're going to look at it de novo. We're going to look at insurance companies. We're going to look at it ourselves. And then it talks about when there's conflicting reasonable interpretations of a word, that is what constitutes ambiguity. And you can come up with various interpretations of what a relative is. Some people consider relatives very broadly. Actually, the Frost court was interesting in that one of the questions by one of the judges to the parties or to the insurance company was, well, how far does this go if we subscribe to the theory that Adam and Eve were the ones that were the first ones on earth, then we're all related. And of course, the insurance company had to admit, well, it doesn't go that broadly. So that's the problem with the word, is it's so broad that we don't really know what it means, and because of that, it should be construed narrowly.
But you wouldn't disagree that it has been defined, albeit perhaps not in this exact type of situation. It's been defined, like in the Groves case, and it's defined in Black's Law Dictionary. It's been defined by Couch on insurance. It's defined. So isn't that also one of the principles of construction that we follow, is we would turn to either established dictionary definitions and or case law that have already opined as to the definition?
Your Honor, that's true, but we can actually find many definitions, because I looked at lots of definitions in dictionaries for the term relative, and actually if you look in one dictionary you can find several.
I spilled some water. I apologize. Don't take time away from him, but I want to. Can we stop the clock for just a second? Let me grab.
I'm always happy when someone else does something I typically do. That's terrible, isn't it? All right. On the point on the definitions, I think there are various definitions you can find even in the same dictionary. There's several definitions for a relative.
Well, specifically to Judge Brown's question in Groves, when I was reading Groves, and it starts in, I think, the second paragraph of that opinion, the policy defines insured as followed, and gives nearly an identical policy definition that we have at issue in this case, and then it drops down later in that same paragraph. Usually relative is defined as a person connected by blood or marriage. Aren't we, Mr. Robinson, bound by our own court's precedent in this case in saying that relative is a person connected by blood or marriage?
Your Honor, respectfully, the answer is no. And the reason is because if you look at the Groves case, it isn't a case involving an exclusion. And there's a difference between how you construe policies for coverage and exclusion. That's the cases are cited within. There's a bunch of cases that say you construe a word that's undefined differently in terms of a coverage provision, because in coverage you're supposed to broadly interpret it to provide coverage to anyone that might have coverage. The Groves case is a coverage case. It's a case where a former son-in-law was living with his mother-in-law and he did something wrong. Doesn't really go into what, and he was trying to get coverage for his liability, and the court said there isn't any way. Basically, it's really dictative in terms of the outcome anyway. The court just basically says there's no way. You're a former son-in-law, you've been divorced for many years, you aren't a relative, you can't be covered. And so that's a coverage case. It's not an exclusion case.
Well, in Groves it also later goes on to say in insurance cases, one not a relative by blood or marriage is not covered as a relative. I mean, I guess so the converse to that is that one that is a relative by blood or marriage is covered as a relative. To me, it seems to be pretty divided in insurance cases. And that's where I'm having a little bit of rub with your argument. But please tell me your position on how I'm missing this.
And I think that the difference is, I think, actually pretty clear when you look at the rules of construction that apply when you're looking at coverage cases versus exclusion cases. The courts specifically, and there are several cases cited in the materials that say, if you have a coverage case, we're going to interpret it broadly. Well, that means you pick the broadest definition possible. That's a big difference. In the case where you're talking about exclusions, because courts don't like exclusions, they say we're going to construe that as narrowly as possible. So now you pick the narrow construction. That's, I think, a major difference. Now, there's only one other Arizona case that Allstate cites as a case that helps them to define what relative means, and it's the Allen case. Allen case is pretty interesting because it's a criminal case. It's a criminal case that involves the victim's rights statute, and in the Allen case, they did talk about some of the things about how to define a relative, but the statute has a very specific definition of what a relative is. The statute says it's, and this is actually interesting because the legislature thought it was important to define what a relative meant, and in that case, they said it's somebody related by blood or marriage to the second degree of consanguinity, which is a word I hadn't seen since law school. Frankly, I can't even remember for sure what that means. But what I know is the legislature knew how to define a relative, and they thought it was important when they were providing protections to victims that they define who the heck a relative is. And so they defined it. Now, I don't want to cast any aspersions on the legislature, but I've had lots of experience. I've been doing this a long time, and there's lots of times where we don't have definitions of important key terms like resident, but here, or relative, here they did. And I think that's important. There are no cases that deal with a definition of a relative on an exclusion case involving insurance coverage in the state of Arizona. The closest case that I was able to find is this Frost case from Wisconsin. In that case, the court again said, that's an ambiguous term, so we're going to construe it narrowly. And that actually involved a blood relative. So when we look at that, and the cases, American Modern Insurance Company, a 1986 case, from the Court of Appeals says exclusionary clauses are more strictly construed than coverage provisions. And then in State Farm versus Partridge, the court said it is Hornbook law that exclusionary clauses are subject to more strict construction than our covered provisions. And then in a couple of other in another place it says it further supports our decision. The general rule is that while coverage clauses are interpreted broadly so as to afford maximum coverage to the insured, exclusionary clauses are interpreted narrowly against the insurer. And I think that's another key point here. Is it's construed against.
The case you talked about earlier, didn't that tell us that we're supposed to interpret policy according to the insured's reasonable expectations? Isn't that kind of our touchstone now as of June at least?
I didn't read it that way, Your Honor. I read it to talk about what normal people might call a relative, but I don't think that's clear what they would call a relative. I think it also talked about it's ambiguous. If you could come up with various definitions, that's the very definition of ambiguity. And in this case, you can come up with different definitions. You can come up with blood relative. You can come up with relatives by blood or marriage. You can come up with, try to limit that someplace. One of the problems here is how in the world do you limit it? Just like in Frost, how would you limit that case? How far does that extend? Does it extend to everyone? Because it doesn't say. It doesn't provide that information. So I think in this case, the problem is Allstate had the opportunity. They're the drafter of the contract. They put these provisions in there. They stick these exclusions in. And Allstate had the chance to define that. It's not unreasonable that they should define it. Courts say that where they don't define it, they're the ones that drafted it. It should be narrowly construed. And as a result, narrowly construed, this should be limited, and it shouldn't be an exclusion that prevents this widow from being able to make a claim as a result of what happened. And if you don't have any other questions, I'd like to reserve the rest of my time for rebuttal.
Thank you, counsel.
Good morning, Your Honors. My name is Sam Alaga. I represent the appellee, Allstate Vehicle and Property Insurance Company. As Your Honors are aware, the facts of this case are undisputed. It is also undisputed that this exclusion in Allstate policy applies if Amelia Maile is held to be both a resident and a relative, or Sheila Maile is a resident and a relative of her mother-in-law, Amelia Maile. Here's what Judge Hanna said in his ruling granting Allstate's motion for summary judgment, and I think he was absolutely right. With respect to the residency issue, Judge Hanna ruled, the relevant time for determining when the person is a resident is the time of the occurrence. And with respect to the relative issue, Judge Hanna ruled, quote, dispositive from a legal point of view that defendants have not cited any case where a definition of relative was held not to include or not to encompass a son-in-law or a daughter-in-law. And Your Honors touched on that point. There is not a single case that doesn't define relative not to include a son-in-law or daughter-in-law. But the converse is correct. We do have binding precedent that Judge Hanna was bound with, which is the Groves case in Arizona that does define the term essentially son-in-law or daughter-in-law to be a relative.
But that was not an exclusion case.
It wasn't, Your Honor.
Nor did the court, well, correct me if I'm wrong, nor did the court even address whether that phrase was ambiguous or not. In contrast to Twofold, I'm sure you've read the, am I saying that right?
I hope so.
I don't know. Twofold case, we'll call it Twofold, where our Supreme Court, walked through the sort of the statutory, I'll call it statutory construction for contracts. I mean, if you follow those principles, it's interpretive principles that you follow. And the court laid those out, but then found, after discussing that there were plausible arguments on both sides, and said the clause, I think it's over the term occurrence, or it was ambiguous. And then the court goes into issues of looking at dictionaries, definitions, looking at the reasonable expectations of the parties, et cetera, et cetera. So my threshold question here is is this that term ambiguous?
Absolutely not.
Why not?
Well, first of all, because we have plenty of case law in Arizona that have looked at the term, and not a single one has said the term is ambiguous. You're correct. If a term is ambiguous, then we look outside to look at the reasonable expectations and all those factors. But here's two things that are being confused here when Mr. Robinson was talking about the broad versus narrow interpretation of a policy. He's correct. We broadly interpret the parts of the policy that grant coverage and narrowly interpret the exclusions. However, that concept is not to be confused with how we define certain terms within the policy. We do not, never have, given a definition to a term in one part of the policy and then define the same term differently when it comes to an exclusion. Another factor that we consider in interpreting policies is we give harmonious effect to the entirety of the policy. How can we give harmonious effect to the entirety of a policy when a single term such as relative is defined one way in one place and another way in another place? We can't, and there's no support in case law for that argument either.
Let's go back to your statement that it's not ambiguous, and maybe I'm misinterpreting what you're saying, but are you saying it's not ambiguous in this case, or it could never be ambiguous?
The term relative as used in insurance policies, when the policy does not define it, I believe cannot be ambiguous because of the Groves case. Because Groves case deals with that exact term, and Groves case does not find it to be ambiguous.
But then, in certain cases, like Frost, I think, where it was a third cousin, you're saying your coverage exclusion, that's a relative by blood or marriage, so it would be excluded under any circumstance.
Okay, so looking at the three cases with regards to relative, I think our answer is found. I think in the Frost case, if we're looking at a third-degree relative, it probably would not meet the definition of relative in Arizona. In Arizona,
but that's a blood relative. It's just by third degree.
That's correct. But then we have.
There is an ambiguity.
Well, there's not, Your Honor. In Arizona, because we have, and I do think Allen versus Sanders case is an important case. I do agree it's a criminal case. There is a statute. However, the Allen versus Sanders case goes on to explain what it means to be related by marriage or affinity. And it says, to illustrate the application of traditional common law definition of affinity, not the statutory definition in the Victims' Bill of Rights, but the common law definition of what it means to be related by affinity. Because David and Shirley were married to each other, David was related by affinity to Shirley's blood relations, her parents, any siblings, and her child, and Shirley was related by affinity to David's blood relations, his parents, any siblings, and his child. So we do have an Arizona case law that defines what it means to be related by affinity. And what it defines, that term, relation by affinity, is I am related to my wife's parents. My wife is a relative of my parents, but my parents are not relatives of my wife's parents. So that's a definition we have in case law that was binding case law for when Judge Hanna decided this case.
Let's assume, for the sake of argument, that we disagree and it is ambiguous. Does your client still prevail here, and why?
I think so, Your Honor, because then we go and we look at reasonable expectations of an ordinary person. Okay, and so what do we have with respect? I guess the common sense test is a daughter-in-law, an ordinary person, consider a daughter-in-law to be a relative of her mother-in-law. I think the answer to me is yes. I consider my mother-in-law to be my relative. But we have more than that. We have cases that I want to know if I want to look at to see if it's the Shelton case that tells us that. But it is the Shelton case, the Ninth Circuit case that cites and relies on Groves. And it says, the term, quote, the term's ordinary meaning requires a connection by blood or affinity. Requires a connection by blood or affinity. And again,
sorry, what was the cite on that case?
Allstate versus Shelton is a Ninth Circuit case that cites to Groves. And Groves, of course, I think is a very important case because it is a Court of Appeals Division 1 case. It does deal with a son-in-law and daughter-in-law, and the only difference is we're looking at the definition of relative in the policy, but not in an exclusionary clause. But again, I stand by my earlier arguments that if we have a case law, a precedent of this court that defines the term relative in a way that would encompass a son-in-law or daughter-in-law, we can't deviate from that just because it happens to be now in an exclusionary clause.
And maybe I didn't read Groves carefully enough, but did the judges in that case make a distinction? This is relative when we're dealing with, you know, a coverage case as opposed to an exclusion case. Did they make that distinction, you know, in Groves?
No, not that. I mean, it's a very, very short opinion. There was no.
I read it thoroughly, but
there was no distinction as to the meaning of a term in different parts of the policy, and I'm not aware of any case in Arizona or elsewhere that says we should define terms differently when they're used in different parts of the policy. We just can't have a definition of a term be two different things in different parts of the policy. Then we can't give harmonious effect to the policy. We can't decide how to read this policy. And again, that's I guess that's my argument with respect to the definition of term relative. And Judge Hanna was correct. There is not a single case that has defined the term relative not to include a son-in-law or daughter-in-law. With respect to, I just want to touch briefly on the residency issue, and the argument by the appellant is, well, first of all, they concede that Sila Maile was a resident of Amelia Maile's household at the time of the fire. And Amelia Maile has testified to that effect, so that's not a point of contention. But appellant's argument is that she somehow ceased to be a resident from the time of the fire at 4 a.m. in the morning until the time of Benjamin Maile's passing later that same day. Again, there's no case law cited by the appellant for support of that argument, and there was none that I could find. The only reliance is on a statute of limitations statute, essentially, and I don't think the statute of limitations has any bearing on when the time frame when we should consider whether someone is a resident. And we do have Arizona cases. The one case is National Fire versus James River, is a decision written, I believe, very artfully by Judge Teelberg. It is not binding precedent, obviously, on this case, a district court decision, but maybe it's just me. I consider Judge Teelberg to be one of the most knowledgeable, if not the most knowledgeable person in the state when it comes to insurance coverage. And he looks at Arizona cases, including Arizona Supreme Court cases, and he states that the term occurrence or accident in insurance policies that define occurrence as an accident, the term accident, quote, clearly implies a misfortune with concomitant damage to a victim. An Allstate policy defines the term accident as, or occurrence as, an accident resulting in bodily injury. So putting those things together, it's clear that in this case, the occurrence or the accident was the fire, and then the bodily injury or the misfortune, as Judge Teelberg stated, is the passing of Benjamin Maile. And I think that there would be some interesting reverse implications if we were to read that, or if we were to adopt the appellant's argument with respect to the time the residency it should be determined. Because if we were to adopt Mr. Robbins's argument, we may have some interesting situations, for example, where a fire happens and a victim goes to the hospital and dies 6 months later as a result of his injuries. But within the 6-month period, the homeowner cancels her insurance policy. So would we not have coverage for that accident? I think that it's pretty clear that we would have coverage because at the time of the fire there was a homeowner's insurance policy in place. Just going back to the relative definition again, and I disagree with Mr. Robinson about the applicability of the Allen versus Sanders case. Allen versus Sanders case doesn't just define the particular Victims' Bill of Rights statute that defines statute. It defines relative or affinity. It goes back and looks at case law from across the United States, looks at the common law definition of the term affinity, which other Arizona cases have clearly said is a relation, or they have said that the relative is connection by blood or affinity, and it determines what affinity really means. So it's more than just a interpretation of a particular statute, but it's a binding precedent on what it means to be connected to someone by affinity. And it quotes from cases across the U.S. which say a husband is related by affinity to the blood relatives of his wife. Marriage will relate the husband by affinity to the wife's blood relations. And it goes under common law, an affinity relationship exists between one spouse and the other spouse's blood relatives.
Why doesn't your client just add a little definition to the policy language? It seems like at least since 2002, in the Frost case, that this has been an issue. And you can add 2 lines that say, relative by blood or marriage to the second degree, and we would save a lot of your time, our time, and plaintiff's time.
Well, I tend to agree with you, Judge, and I probably can't answer that question. The only answer I have for you is that is probably not the only term that is a point of contention and that we go before courts and argue about. And I would imagine that there is logistical difficulties in defining multiple terms, and they have to be reviewed by counsel in all 50 states to make sure that they comply with the laws of that state and they're in conformity with the case law in that state. But yeah, I agree with you. If it was defined, we wouldn't be here. I know I have about 5 minutes of my time left. I feel like I have touched on everything that I was going to talk about, unless there's any other questions for me, and I ask the court to affirm Judge Hanna's ruling. Thank you.
Thank you, counsel. Mr. Robinson.
Your Honors, just a couple points that I want to touch on. First of all, one of the things that Allstate wants to argue is that Judge Hanna was correct in saying that we didn't find any cases that say a daughter-in-law is not a relative. And that's true, we didn't find any. But that is the wrong question, in my opinion. I think the Kiegi case, an Arizona case back from 2000, Kiegi versus Northbrook Property Casualty, cited in our materials at page 25 of the opening brief, says the burden, when you've got something like this, the burden's not on the person making the claim, the burden's on the insurance company. Why is that? Well, of course, the reason is because the insurance company is the one that didn't define it. And so the burden was on them, not on us. Interestingly enough, if you turn it the other way, they didn't cite you any cases where they said a daughter-in-law in these kind of circumstances is a relative when we're talking about an exclusion provision.
Let me ask you a variation on that bad question that you don't like. Instead of just daughter-in-law and son-in-law, is there any case or any authority for the proposition that we just should distinguish relative based upon blood versus marriage? In other words, your argument earlier was construe it narrowly, construe it only blood relations. Right. Is there any support for that? Any case that says, a relative by marriage is not a relative?
You know, I have not found any cases that say that, and certainly, obviously, I've looked for them, but there are. But it hasn't really been addressed that I could find. There are certainly in definitions. I looked at definitions, and there are. If you just look in Webster's or whatever, you can find all kinds of different definitions. Just in every dictionary, there might be 10 different definitions. And so there's even that gives you room for argument. What the heck does relative mean? Well, it depends on the context. It depends on, who's talking about a relative. Who might be a relative to you might not be a relative to me. I know a culture where actually almost everybody is a relative. This is my cousin. They'll say, this is my cousin. Well, they're not really their cousin. But that's it depends on who it is. But I think that's where we come to the term of ambiguity. That's why the Frost Court found that this was ambiguous, and it's essentially the same provision. It's a little different circumstance, but when you get to the issue, it's ambiguous. Then you come to, well, how do we interpret it? Well, we interpret it narrowly. Now, the other case that they cite that supports their position is a Ninth Circuit case, Allstate versus Shelton, as we pointed out in the materials. It's also a coverage case. It doesn't really tell us what should happen here, because when you look at, and that's a major thing. The cases make that a major thing. Coverage, broad. Exclusion, narrow. And actually, if you think about why that is, that makes perfect sense. The courts want these policies to be enforced. They want people that should have coverage to have coverage, and if they haven't defined it well enough, it's ambiguous.
Well, touch upon his argument, because as I understood your opposing counsel's argument was the definition of insured person is not necessarily, in this case, an exclusionary clause. It's just a definition. It says insured person includes A, B, and C. And actually included, it's kind of an inclusion at this point, because it said insured person includes resident relatives. And then later on, there's an exclusionary provision that says insured persons are excluded under this case. So in one way, isn't it going to create problems if we say, well, for all the purposes that insured person is going to be a coverage provision, we would include it broadly, so you'd probably cover resident relatives in a lot of cases in that way. But here, because insured person is in the exclusion, we're going to construe it narrowly. Does that, do you see the tension there?
I don't see that it's really a problem. I mean, here we have one case in the state of Arizona. In all the history of the state of Arizona is groves that we've been arguing about. We got one case that was a coverage case. Wasn't really necessary to even the determination, hardly to even. They just picked any kind of definition you could pick of relative, and he didn't fit. We've never had the issue decided. So is it a big problem? I don't think it's a big problem. And the reality is, you do in all kinds of contexts when we have definitions of words. Some definitions apply in some circumstances, and they don't in others. It doesn't apply. It doesn't apply in the exclusion situation. It's interpreted. You pick the narrow definition as opposed to the broad definition. Is that wrong? They're the ones that drafted the policy. They're the ones that it gets interpreted against, and that's what we'd ask you to do. And I've run out of time. I'm sorry.
That's fine.
Thank you.
Thank you, counsel, for your briefs and your presentation here today. Both were well done. We appreciate it. We will take the matter under advisement, and we'll issue a written in due course. The court now stands adjourned. Thank you.